Good afternoon, everyone. It is with great pleasure to welcome you to this panel on judicial intervention and party autonomy, the evolving role of anti-suit injunctions. This is a particularly relevant and timely topic, one that has been subject of extensive scholarship by Columbia faculty, including Professor Berman, Smit, and Dabhol. We are joined by an exceptional group of speakers, Caline Mouawad, Jorge Asali, Tyler Robinson, and Cristián Conejero, with Professor Robert Smit as our moderator. Their experience and standing speak for themselves and need no further introduction. With that, Professor Smit, we look forward to your opening remarks.
Thank you. The panelists will be reminded to hold the microphones close to your mouth. I am going to start with my favorite war story. Here's how it goes. General Electric and Bechtel contracts to build a $6 billion power project in Maharashtra, India. They build the project, and then the Indian government refuses to pay for the power generated by the project. So GE and Bechtel, invoking the power purchase agreement arbitration provisions, start an uncitral arbitration in London. But the Indian state parties go to the Indian courts and get an anti-arbitration injunction targeting the London arbitration. The Indian member of the London arbitration and the parties were unwilling to proceed, so they brought the arbitration to a halt. Then GE and Bechtel hired Simpson Thacher, us, and several of us have worked on this case, and we started a new arbitration, this time in New York, under the shareholders agreement, an ICC arbitration. At the same time that we started it, we went to the Southern District of New York, and we successfully petitioned the New York court for an anti-suit injunction, preventing the Indian party from going to an Indian court to try to enjoin our New York arbitration. Next thing that happens, the Indian parties go to the Indian courts and get an anti-arbitration injunction targeting the New York arbitration, as well as an anti-suit injunction preventing us from pursuing our anti-suit injunction against them seeking anti-arbitration injunction. What happened next? You can guess. We went back to the Southern District and we got a contempt order against them for breaching the Southern District's anti-suit injunction. What did they do? They went back to the Indian courts and they got from the Indian courts a contempt order for our breach of their anti-suit and anti-arbitration injunctions. So we have dueling international contempt orders. I often tell my students that international arbitration is a wonderful opportunity to travel, but sometimes it prevents travel because I still have an extant contempt order against me in India, so I have not been able to go to India. We did start a bilateral investment treaty alleging in part that India's issuance of anti-arbitration injunctions and anti-suit injunctions violated their bilateral investment treaty arbitrations. And that case, I was with Jack Kerr on that, settled the day before trial started. But my little story illustrates the subject matter of our panel, which are anti-suit injunctions and anti-arbitration injunctions. And international arbitration is a rich tapestry for these injunctions triggering concerns about the autonomy of international arbitration and the sovereignty of national courts. The common law and the civil law have adopted very different approaches to issuing anti-suit and anti-arbitration injunctions that we are going to explore with the panel. But ask yourselves what Professor Berman would ask. Sorry to put words in your mouth, George, but which approach is pro-arbitration? Another angle we'd like to explore is, as opposed to common law or civil law courts issuing these injunctions, what about international arbitrators themselves issuing the injunctions? Another fertile area for discussion. And finally, is the availability of anti-suit injunctions different in commercial arbitration than investment arbitration? So with that introduction, I want to start us off first with the common law, civil law divide. Very generally speaking, and I'm going to overgeneralize this entire panel, common law courts are more willing to issue both anti-suit injunctions and anti-arbitration injunctions. Sometimes anti-arbitration injunctions are known as stays of arbitration. There are three different kinds of injunctions, I think. The first is anti-suit injunctions targeting litigation that is commenced in violation of an international arbitration agreement. The next are anti-arbitration injunctions, what I would call the bad kind, where you're targeting arbitrations commenced with jurisdiction. And the third kind are anti-arbitration injunctions, which you might call good arbitration injunctions, which are targeting arbitrations commenced without proper arbitral jurisdiction, or an arbitrator issuing an injunction against a parallel proceeding that competes with his or her own proceeding. So with that, I'd like to ask our panelists to describe the approach first of the common law and then of the civil law to these kinds of injunctions. Tyler, if you could kick us off on the common law approach, why are you so injunction happy?
Count on Professor Smit to start this panel with the most convoluted and insane story of anti-suit injunctions against anti-suit injunctions. But stepping back and just thinking conceptually, I think the common law approach largely just tries to vindicate the multilateral scheme represented by the New York Convention. And so the most straightforward rationale and justification for being anti-suit injunction happy is if you are the court at the seat and you have that jurisdiction to be responsible for the parties' agreement to arbitrate. It starts there, and you enforce that agreement to arbitrate by virtue of the injunction, because that's what the parties have agreed, and they've submitted themselves to your seat and your law for that purpose. Now, if there's some other court somewhere else that's seized of a litigation in breach of that arbitration agreement, from the common law perspective, that other court should either be in violent agreement that the parties should arbitrate and that the case before it should not proceed, or if it is not, then it is that other court that is thumbing its nose at comity and at international law. Because under the New York Convention, it should be for the seat court to have primary jurisdiction over the parties' agreement to arbitrate. Another very important feature of ASIs, anti-suit injunctions, which I think distinguishes it from anti-arbitration injunctions, is that from a common law perspective, there is an irreparable harm to be remedied by the injunction, and that is the loss of the right and opportunity to arbitrate a dispute versus having some jurisdiction resolve it in a court that was never agreed to be the place for the merits to be resolved. And from the common law perspective, an anti-suit injunction serves to remedy that irreparable harm because you can't otherwise solve it with money. When it comes to anti-arbitration injunctions, I think the position is different, and common law courts certainly think they have the power to do it, but rarely do. And again, in service to the New York Convention, why is that sort of a different perspective? Well, because arbitrators are supposed to exercise competence and have the opportunity to decide their own jurisdiction, as a result of which there's an opportunity for courts at the back end to solve for an invalid arbitration, both in the enforcement court and at the seat. They can, after the arbitration happens, say the arbitral tribunal didn't have jurisdiction. So in that sense, there isn't an irreparable harm, arguably, because there is a solution down the road, and it becomes a question of, well, wasted costs and whatnot to go through the motions of an arbitration that shouldn't happen. But that is remediable by money, or you just don't show up, you don't expend the costs, and then you fight that arbitration on the enforcement end. So I think in both instances, the common law courts are really trying to vindicate the scheme of the New York Convention.
Well, let me push back for a second. In preparation for our panel, I reread the Federal Arbitration Act and the New York Convention, and I couldn't find any authority for issuing anti-arbitration injunctions. So I went to Bourne's treatise, and he says anti-arbitration injunctions are fundamentally inconsistent with the architecture of the New York Convention, with the competence of arbitrators. Why is Bourne wrong?
Well, way to tee it up, Rob. He's not wrong, but arguably you'd say a court, when it exercises its injunctive powers, is exercising equitable, discretionary powers that certainly the English courts and the US courts have without having to root that in the New York Convention or any statute that's arbitration specific. What makes anti-arbitration injunctions, I think, more difficult, though, is at the end of the day, the New York Convention should counsel in favor of letting the arbitrators decide their own jurisdiction. Now, if the common law court is the court at the seat, and it's ultimately going to say there's no valid arbitration agreement, one argument might be to say, well, why waste everybody's time? If that's the outcome at the seat, say so and injunct the arbitration. The shortcoming of that, even from a common law perspective, is that in the New York Convention scheme, it should be open both to the arbitrators and to ultimate enforcement courts elsewhere to take their own view. And if you injunct the arbitration, none of them get to. And so it's a bit out ahead of your skis to tell everybody else what the outcome should be. And I've actually had a case with you, Rob, although it carried on for 12 years and including after your retirement, where the seat was Brazil. Brazilian law governed the arbitration agreement. There was a question whether there was a valid arbitration agreement as respects a non-signatory, our client. And the courts at Brazil in the seat said, yes, there is. When they came to enforce it in New York, the US courts said, no, there isn't. And then they went and they sought to enforce the same award in the Cayman Islands because there was a fund entity in the Caymans, and that brings in English law. And the English courts ultimately said to the highest authority of the Privy Council that the arbitration agreement was governed by Brazilian law. The Brazilian courts had said there was an arbitration agreement, res judicata, done and dusted, you're stuck. And so you had two common law courts actually disagreeing with each other about whether there was a valid arbitration agreement at all, and very legitimately so, based on a choice of law issue. So when that happens, I think it highlights how every court should kind of have its opportunity to decide for itself in the New York Convention scheme.
Yeah, and I think it's fair to say that whereas there's no uniform approach in the U.S., most all U.S. courts recognize their authority to issue anti-arbitration injunctions and adopt different standards as to whether they're willing to exercise their discretion to do so. The authority is found in three places. Some courts suggest that the FAA and New York Convention provisions providing for the enforcement of arbitration awards imply a concomitant authority to stay arbitrations issued without arbitral authority. Other courts will rely on state laws like CPLR 7503 that statutorily provide for stays of arbitration. And a third source is the court's inherent authority over the parties before it to protect its jurisdiction if the court deems that the parties have not agreed to arbitrate. And whenever we resist arbitration, we always come back to first options, and we say it is federal arbitration policy to enforce arbitration agreements where parties have agreed to arbitrate, but it is equally compelling Federal Arbitration Act policy not to require parties to arbitrate who haven't agreed to arbitrate. So if you haven't agreed to arbitrate, what's wrong with enjoining a party who has commenced an improper arbitration? Perhaps the civil law proponents can explain your approach, your reticence to issue these kinds of injunctions.
Thank you very much, Rob, and I will just seize this opportunity very briefly to express my gratitude for the Columbia Arbitration Association and specifically to George, and as well as my admiration. I was an LLM student here 24 years ago, and I had the privilege of being a student in one of George's classes, Transnational Litigation or Arbitration, and 10 years after, we rejoined again in a tribunal in which I was co-arbitrator and he was the chair, and again, he taught me a master class on arbitration in action. And I truly believe that what George and other professors, such as late Professor Hans Smit, Professor Garro, and the next generation, Rob, Kabir, and many others, have built here is quite unique and inspiring in terms of truly fostering an arbitration ecosystem within the law school that you don't see elsewhere. So for all of you that are attending or have attended classes here, you are privileged and you should keep that in mind, because at least in my case, it really proved to be a game-changing experience in terms of how to continue building a career in the international arbitration sphere. Having said that, and going back to Rob's question, when you talk about Latin America, you need to bear in mind that Latin America is still new to arbitration. Until the 80s, very few countries in the region have adopted the New York Convention, let alone the UNCITRAL model law. The first country was Mexico in 1993, and most of the countries started the reform on arbitration in the late 20th century. At least 17 countries have enacted laws within the last 15 years. So it's quite recent, and that means that many of the features of arbitration are still not well understood and are applied almost automatically, not to say formalistically. That means in practice that you don't see often things like anti-suit injunctions or anti-arbitration injunctions, although I will get back to a specific experience that have resound in the world of arbitration in Latin America because of the impact of those cases. But what you see in turn is the typical conundrum or conflict of the application of Article 2 of the New York Convention, Article 8 of the UNCITRAL model law, which is in basic terms that a party that believes has a valid existing arbitration agreement resorts to arbitration, while a recalcitrant party goes to a local court alleging for whatever reason that the arbitration is null, invalid, or inoperative. And tribunals tend sometimes to take a very broad view on what is the inherent question that they need to resolve at that stage. And there have been cases in which they have dwelt with questions of arbitrability, in ways that prevent ultimately the tribunal to properly apply the principle or the power of competence-competence. And that is generally what happens in terms of frustrating the purpose of arbitration rather than truly seeing anti-arbitration injunctions as you see it probably in common law. There are two reasons for that. First, you don't have procedural features such as motion to compel for arbitration like you see here in the US. So the normal route will be to allege lack of jurisdiction of local courts and then ask the court to defer the parties or refer the parties to arbitration. And the second reason is that there tend to be a lot of deference to foreign courts, including arbitral courts, in terms of committee and reciprocity. That being said, there are some cases in which, as I said, anti-arbitration injunctions have been issued, especially in Brazil, Argentina, Venezuela, and I won't get into the details of each case, but it suffices to mention that the general reasons relate either to the fact that there are a public interest involved, which is one of the principles that were embraced by Venezuelan constitutional courts and by Argentine courts in the Yacyretá case, and then later on in the YPF case against AS Ingeniería. The same happened in the Copel case in Brazil, where there was a state-owned company that went to look for refuge in Brazilian courts, and a parallel arbitration started in Paris in conformity with the terms of the contract that called for an ICC arbitration in Paris. The outcome was different because in the first case, in the Yacyretá case, the place of arbitration was Buenos Aires, and the local courts imposed not only a millionaire fine on the claimant, but also an order of contempt of court on each of the arbitrators, and two of them were residing nationals in Argentina, which called for a different subject, which is the importance of the place of arbitration. Whereas in the Copel case, the tribunal decided to move on with the arbitration and ultimately issue an award, considering that the main issue that called into question the arbitrability of the state-owned company had to be resolved in accordance with French arbitration law, being the lex arbitri, and not in accordance with substantive civil laws, Brazilian civil provisions, which were referred by the state-owned company when calling into question the so-called capacity of the Copel entity. But these cases ultimately show that local courts probably have some sort of misunderstanding in terms of how much they can reach out in order to frustrate arbitrations that are being conducted on the basis of a valid arbitration agreement when they believe somehow that there are public concerns that are beyond the question of arbitrability and therefore cannot be validly submitted to arbitration. Just to finish the point, there are other measures that ultimately can prevent an arbitration from moving forward without being labeled per se as an anti-arbitration injunction, and that is typically the case of some constitutional recourses that we've seen in Venezuela, in Ecuador, in Colombia, and also in Mexico, but I will leave that to Jorge, with the so-called amparo indirecto, especially that allows superior courts to have a second bite at the apple on the question of whether the parties should be referred or not to arbitration when the lower court has decided that there is a valid arbitration agreement. So there is, a lot of things evolving, but I would say that the summary is that we still have lessons to learn in terms of how much can national courts do legitimately in order to prevent arbitration from moving forward.
Jorge, do you want to add something?
Yes, always. Thank you, Rob. First of all, I want to thank Columbia for inviting me to speak today, especially when it's Mr. Professor Berman's 50th year here. So thank you very much to the organizers. Second, I know this is a hard panel because we just came after lunch. And sometimes after lunch, everyone is a little bit sleepy and we need to be shook. And so thank you for being part of this panel. And third, of course, everything Cristián said is right. So what have I to say? Let me come from left field and let me add some different stuff here. As Cristián just said, civil law jurisdictions have generally been reluctant to recognize anti-suit injunctions as a formal procedural remedy. Why? We have various reasons. Judicial sovereignty, mutual trust and deference between courts, the principle of international comity, and respect to other jurisdictions. So why avoid anti-suit injunctions? There are many reasons. And when I was preparing, after Rob asked me to concentrate on the subjects I was going to discuss, and I know this is a very sophisticated audience, so I'm going to ask you to bear with me for a second. I came back to why is arbitration so tough sometimes to try to understand, to chew. And I think arbitration punches at the gut of one of the state's core issues, the administering of justice. One of the oldest and probably most important and beautiful functions of the state represents to say who is right and who is wrong. And if we're lawyers here, everyone's desire, I know when I started law school, I want to be a judge. I want to be able to say who's right and who's wrong. And what does arbitrations do? Why will the state relinquish? Why will the state surrender this most important of its main functions? So why will private individuals be granted the right to say who's right and who's wrong? The answer for me ultimately lies on the welfare of their citizens. Why? Because every country wants to bring the most benefits to their citizens, and then if you want benefits and you want investments, you want predictability and you want money to flow, and then you want and you need the most specialized guys resolving the issues. And then you turn around and say, hey, arbitrators, come, please. And I think that's what happened in Mexico. And I'm going to talk a little bit about Mexico and Latin America because that's what I know. I think that's what happened in Mexico around the turn of the century when we wanted to attract all the investments from NAFTA. And they said, okay, so we don't trust your courts. We need arbitration processes. And just as Cristián said, we changed the law. We became pro-arbitration. And why did we become pro-arbitration? Because we wanted the investments. I have to make a parenthesis here, and I'll occupy just 1 second. As some of you may know, Mexico just went through a travesty of its judicial power. Right now, Mexico will no longer have judges, but those elected by popular vote, from the highest court to the lowest court. Everyone in Mexico every judge in Mexico, Supreme Court justices or the lowest of the low, will be elected by popular vote. Oh my God. If this sounds terrible, it is because it is. We cannot right now say how the experiment is going to come. I don't think it's going to be a good experiment, but we still have to wait on the results. So why am I making this parenthesis? Because arbitration becomes the first line of defense to try to obtain justice in Mexico. Arbitration is now more than ever important. And in developing countries, at least, where we're still trying to manage and trying to find out how arbitration is going to accommodate itself, it's only been a practice for the last 20 years, so to speak. We need legislation that provides certainty, predictability, and the question is, do we have those instruments? My answer in Mexico is that legislation was introduced to provide arbitration with enough teeth to make it compete, to make it withstand, to make it a good option against the legal regime. Thus, legislation did not go as far as recognizing anti-suit injunctions. They didn't go as far. Not as a formal procedure, but nevertheless, we have developed a functional approach, an indirect path that provides for judges and arbitral tribunals to grant equivalent measures and to provide judges with the capacity to grant, as we call them, precautionary measures to protect the effectiveness of arbitration. These are general, these abstract, these are not straight. We have to go do a little topsy-turvy to get to where we want, but we can get there. And precedents in Mexican courts, at least, have now recognized this sinuous way to provide arbitration with effectiveness and strength. And I will leave it there because I can go speak for hours, but Professor, please go ahead.
No, let me piggyback on both of your comments. I understand that in Mexico and other civil law jurisdictions, there isn't the breadth of injunctive relief statutorily enshrined. You don't have motions to compel arbitration, you just stay litigation of issues that should be arbitrated. But there have been plenty of civil law countries who have nevertheless found a way to issue anti-arbitration injunctions. Indonesia come to mind, and other countries as well. And you say you are still learning. There's much to learn. So the question is, from a normative perspective, what should civil and common law countries alike do? Should a court be willing to issue an anti-suit injunction against proceeding with foreign litigation in order to further the pro-arbitration policies of the FAA? You're balancing U.S. statutory and treaty arbitration policies against somewhat, amorphous international comedy policies. And what about anti-arbitration injunctions? The U.S. courts that have issued anti-arbitration injunctions insist that they are pro-arbitration because they are preserving the sanctity of arbitration and the consent basis of arbitration and preventing proliferation of different arbitral proceedings. So this is all a long-winded way of saying, are anti-suit injunctions and anti-arbitration injunctions a good idea, or should they not exist?
They are an excellent idea, and it's just not an idea, it's a necessity. You always want to protect the effectiveness of arbitration. You need sometimes your local, your national courts, and even a tribunal to protect consent. Yesterday, it was a very big theme in the presentations. Consent is a cornerstone of arbitration. So if you want to protect that consent, you need the anti-suit injunctions, you need the anti-arbitration injunctions to protect them. And once again, at least in Mexico, we have several ways to protect them. They may not be the straightforward ones, the ones that we would enjoy as a civil law jurisdiction. You only go from A to B because we already have that inscribed in the law. But you have to get there, and you need to get there. Sorry, Kristen.
And Caline, I'm not forgetting you. You are going to be carrying the laboring oar when we get to investment treaty arbitration. But what about from the international arbitrator's perspective? I think arbitrators are understandably shy to issue anti-suit injunctions and anti-arbitration injunctions of their own. But I've had a case, Marc Lalonde issued an anti-suit injunction in one of my cases against a Saipem proceeding and a parallel arbitration. Do you have any experience or words of wisdom for arbitrators considering issuing their own anti-suit injunctions and anti-arbitration injunctions?
Well, I may be able to share one. It's not a situation that in which I wanted to be, but unfortunately it happened, and this was part of the Gazprom saga cases after the Russia-Ukraine war started. In the post-2022, there was shortage of gas supply agreements between Gazprom and a number of Western European off-takers. And I had the chance to preside a case, an ICC case seated in Geneva, which became later public. And I won't get into the specifics of the case, but at least I will share with you my experience within the tribunal as to how to face a situation in which the Russian party, Gazprom, initially participated, arguing that the place of arbitration, establishing the arbitration agreement, which was Geneva, was an unfair place in light of the war that has already started, as Switzerland was no longer neutral. At that point in time, as tribunal and upon the initiative of claimant itself, we tried to persuade Gazprom of looking for other places for arbitration. We were quite creative. We looked for Middle East, maybe not right now, a good place to suggest, but at that point in time, there were some good places where we could conduct the case. And even some other places, but from that point on, Gazprom decided to not participate anymore in the case and went to Russian courts to seek and obtain an anti-arbitration injunction, basically ordering, in this case, the claimant says that Czech state-owned company to cease arbitration and submit to the Russian courts because the dispute was no longer arbitrable in light of these concerns about Switzerland not being the right place. We saw how things would evolve, but it became quite clear at some point that Gazprom would obtain not only an order, but also a fine, quite relevant, equivalent actually to the face value of the claim pursued by CES, in case claimant would decide to continue with the arbitration. And at that point, we decided to issue an anti-suit injunction, but with a number of elements that we had in mind in order to avoid any perceived violation or lack of deference towards international committee. And so the first thing we had clear is that the order had to be solely directed at Gazprom as a party bound by the arbitration agreement and therefore submitted to the arbitration. And that was crystal clear. Actually, Gazprom had not alleged that the tribunal was deprived of jurisdiction. It rather alleged that the way the arbitration has unfolded was no longer fair for their interest. Second, we thought that it was the only way to preserve the party autonomy principle and the party's consent to arbitrate. Otherwise, if we let basically claimant by himself and we cease arbitration, then claimant would be trapped in a situation in which we will no longer have the ability to pursue their claims in arbitration with an outcome that would run contrary to the purpose of what was stipulated when they agreed to arbitrate. Third, preservation of rights and avoidance of abuse of process. And we truly believed that the way in this case the Russian entity was behaving was somewhat depriving the arbitration of any meaningful value by seeking refuge in their own local courts in a way that would clearly be detrimental to the outcome of the case. So the only way to preserve CES rights within the arbitration was to continue with the arbitration until a final award was rendered. And finally, and this was a very technical thing that was mostly the contribution of our Swiss arbitration in this case was Professor Ponset, under the appeal regime, an order of this nature, an Astrant order issued by a foreign court that ran contrary to the arbitration agreement would not even be enforceable within the Swiss arbitration regime, and therefore we didn't have to provide any sort of deference or recognition to that order. Later on, many other cases followed suit and took the same stance. Hopefully, we were not alone on that boat, and ultimately that helped many other off-takers to have arbitral awards that became enforceable. But it was quite a challenge, indeed.
Jorge, have you had experience of an arbitrator issuing an anti-arbitration injunction against another arbitration, the parallel arbitration experience?
Yes, but not with arbitrators, judges quashing arbitrations.
I see.
And on the why? Basically, to maintain coherence of a first ruling or to protect an ongoing arbitrations. So you go to the national judge or to the local judge and you ask him, please stop, please stay, please quash. And results have been amazingly good. They have in Mexico, you have this general capacity to emit precautionary measures. And the only requisite you have to comply with is you cannot violate public policy of public orders. That's a whole story different. But so as long as you maintain yourself in trying to maintain a status quo, my experience in Latin America, they will grant you the anti-arbitration injunction.
I want to turn for a minute to the practical and strategic consequences of anti-suit injunctions and anti-arbitration injunctions from the perspective both of counsel and arbitrators. As counsel, do you advise your clients to comply with or defy what you consider to be an improperly issued anti-suit injunction or anti-arbitration injunction. It puts you in an awkward position. And as arbitrator, what do you do if you're targeted by an anti-arbitration injunction that you think is wrongfully issued? Do you proceed with the arbitration or not? Anyone?
Comply.
Always comply.
You're trying to protect the final award, and I think the best way to do it is to comply. But Tyler, please.
Well, I was going to say, and my feelings on this are informed by advising clients also when they're doing transactions, whether or not to agree to arbitration, and if so, on what terms. I think it enters the conversation what expectations clients have when they choose arbitration. And listening to the perspective about how arbitrators deal with some wild myriad of injunctions, dueling and competing and trying to stop the arbitration from happening, there's no doubt that clients choose arbitration in order to avoid that sort of thing, in order to avoid bad behavior by courts they don't want to be subjected to. And so, from my perspective, primarily as counsel, I would hope that arbitrators would always exercise the independence of mind, even with the seat court, potentially, to decide for themselves what's the right thing to do. When it comes to clients, I would never advise a client comply or don't comply. I would say, here are the risks and rewards of whether you do or you don't, and make sure that it's their decision. But I think some of the considerations that would enter the conversation would be what's the jurisdiction that's most important for ultimate enforcement? Where's the seat, of course? What jurisdiction do you want to decide whether you do or don't have a valid arbitration agreement, and what are the res judicata implications of that? Where do your arbitrators come from? Where do your witnesses and evidence come from? And what are the implications of an injunction from one direction or another interfering with all of that? So I think there's a case to be made for compliance and for non-compliance, and my poor clients have to make it for themselves.
Well, I mean, it would be the audacious arbitrator indeed who would disregard an anti-arbitration injunction issued by the seat courts. The harder question is if, as in my Dabhol case, it was a secondary jurisdiction issuing an anti-suit injunction. And there, it's easy to say, well, the Indian courts had no jurisdiction with respect to a London-based arbitration. But as a practical matter, one of the arbitrators was a former Indian Supreme Court justice. Many of the witnesses were Indian parties, and even if the arbitrators and our clients could avoid India, they couldn't. So as a practical matter, I don't second guess the UNCITRAL tribunal's decision to shut down their arbitration. But that was a decision driven by practical considerations more than legal ones. Perhaps we should turn to the investment area. And this is an area where the presence of a sovereign on one side can have significant implications kind of in the balance of factors as to whether to issue anti-suit injunctions. Caline, do you want to launch us into how the role of anti-suit injunctions in the investment arbitration context?
Sure. Do you want me to get into liability as well, or that'll be a second question?
Excuse me?
The liability issue, do you want me to do that later? Or-
Yeah, well, okay. If you don't get there, I'll follow up with the question.
Okay, very good. So I was going to address it sort of in three parts, because I think the preliminary point is the context in which these kinds of injunctions are issued in investor-state arbitration. And I think the best place to look at that is in interim measures in investor-state arbitration, because that's often the time when you're seeking an anti-suit injunction to stop local proceedings. And what we see from the jurisprudence in that space is that tribunals will issue anti-suit injunctions when they need to protect their own exclusive jurisdiction under ICSID, for example, or to try to make sure that the final award is not ineffectual, as you mentioned, Cristián. But sort of the main reason, that tribunals invoke when they're issuing these kinds of injunctions is to preserve the status quo and to prevent the aggravation of the dispute. And under that umbrella, you see in the cases that they have issued anti-suit injunctions in, just mentioned 3 main buckets. One is to stop the enforcement of judgments that could be threatening arbitration, and the poster child for that is the Chevron v. Ecuador case. I see Doak was here. I don't know where he is, if he's still here. Oh, there you are. So I'll come back to that case that we worked on together for a very long time. You also have instances where tribunals are halting criminal proceedings that are ongoing that may or may not have been politically minded or intended to impact the investor-state arbitration, to try to intimidate witnesses or to have their credibility impugned by having some kind of a criminal conviction. And we've seen that in cases like City Oriente versus Ecuador, Quiborax versus Bolivia, where tribunals have been minded to enjoin criminal proceedings. It's a higher threshold, obviously, because of the sovereign right to pursue and to punish crimes, but there is precedent for that. And we also see them exercising their discretion to enjoin local proceedings in the context of bankruptcy proceedings, where those bankruptcy proceedings could have an impact on the subject matter before the tribunal. So this is CSOB versus Slovak Republic. Investment arbitrators, investment tribunals are not shy about issuing anti-suit injunctions, and so long as they're doing so in order to mainly preserve the status quo or prevent the aggravation of the dispute as it's developing in real time on the ground. And so the question you pose is, what are the unique issues, or what unique issues arise in the context of investment arbitration and anti-suit injunction in investor-state arbitration? And there are several buckets. I think the first is obviously sovereignty concerns and interference with the state's judicial powers. So coming in and telling a state, you can't prosecute this claim, or you need to halt this proceeding, and what that does in terms of comity and interfering with sovereign powers. Anti-state injunctions are directed at the party, not the proceeding, and in this case, it would be directed at the state. So there's a question of whether you're interfering, and oftentimes you'll hear from states saying, well, we can't possibly suspend this litigation or interfere in this litigation to which we may or may not be a party, because in fact, by doing that, we would be actually doing the precise thing that you reproach us by not having an independent judiciary or otherwise. So there's this tension about how to deal with, with enjoining the party in front of you, which is the state with a capital S, to somehow stop a litigation to which it may or may not be a party in the local courts. Now, the comeback to that is that obviously, because it is an investor-state arbitration and it is the state with a capital S, then all of its organs under international law are bound by any order that the tribunal issues. And so the argument goes and that you, the judiciary, are actually directly bound by the order from the tribunal, as opposed to binding the executive that should then go interfere in the judicial proceeding. So it's actually a direct order on one of the organs of the state, that being the judiciary. And we've seen that argument come up several times, and I'll talk in a minute about how, I'll just do it now. I mean, in City Oriente versus Ecuador, the court had a proceeding before it, and once the interim measures order came down, it said, well, there's a legal impediment to us continuing this case, actually, because there's this injunction that says we have to halt the proceedings. So that was a way to sort of artfully comply with the anti-suit injunction. In the Chevron case, we had a very different reaction from the Ecuadorian courts, which was basically they'll just do whatever they want, and they ignored the tribunal's interim measures order requiring them to stop the enforcement of the judgment or rendering the judgment enforceable. So That's one issue, sovereign issues and the, sort of the interference with the judiciary. There's also sometimes a conflict between international law and domestic law. So sometimes states will argue, and we again, I'm basing this off of our Chevron case, the state will argue that, well, we can't comply, even if you've enjoined us to do this, we can't comply because of all these internal rules and domestic laws that we have that prevent us from doing so, and there's no mechanism under domestic law that we could invoke in order to comply with your order. Of course, to which the response is, well, under international law, you can't hide behind your domestic law to justify your failure to comply with your international obligations. So that's another area that's quite specific in that space. And I think just in the interest of time, the last one that I'll raise is the enforcement of those interim measures. So you get them, and then what do you do with them? Where do you go with them? You're going to go to the local courts and try to enforce them? I mean, good luck. And so that's a real question about what you can do with that. And I already mentioned what happened in City Oriente and then what happened in Chevron. So, I mean, I think one of the things that we did in the Chevron case was that we obtained a declaration of breach of the interim measures award. And then ultimately we were able to take that when the judgment was being enforced in different jurisdictions, we were able to take that declaration of breach to say, hey, this judgment became enforceable in breach of interim measures awards, so you, the enforcement court, actually shouldn't honor that because that is a breach that was obtained in breach of international law. So that was a way to try to fight that off pending the final decision on the merits of the tribunal, which ultimately found that the judgment itself was a denial of justice and couldn't be enforced anywhere in the world. But I think I'll stop there in terms of sort of the special considerations in investor-state arbitration.
What about the question about whether a state's issuance of an improper anti-arbitration injunction can trigger liability under a bilateral investment treaty? I mean, in my Dabhol case, that was the issue. It wasn't resolved because the case was settled, but in a prior OPIC arbitration, the OPIC tribunal found that India's issue of an anti-arbitration injunction violated its international obligations.
So a couple of cases that I wanted to mention in that, and actually there's a third one that is ongoing, and I guess we'll get an answer on that one. The first is the Saipem versus Bangladesh case, where basically there had been an ICC arbitration. The Bangladesh courts had, in the meantime, enjoined the arbitration from proceeding. The claimant continued the case, obtained a favorable award, and then that was ultimately, it wasn't even set aside because the Bangladeshi court said there's nothing to set aside because this was never properly obtained because you were enjoined and you shouldn't have pursued the arbitration. And so Saipem went to file an ICSID claim saying that basically the anti-arbitration injunction and then the revocation of any arbitration agreement, the revocation of the tribunal's authority to proceed amounted to an expropriation of a right. And that's what the tribunal found, that in fact that had been a violation and an expropriation, and that the courts, which were the primary jurisdiction courts, had abused their discretion in issuing the anti-arbitration injunction. So that's one case. Another case, which is not exactly like it, but I do think it's analogous, is the ATA versus Jordan case, which basically they went to arbitration, local arbitration, won. That award was ultimately annulled. In the meantime, a law had been passed that said whenever an award is annulled, then the arbitration agreement falls. So you can't go back and arbitrate, you have to go and litigate. So they brought an ICSID, I think it was ICSID, yes, an ICSID claim saying, well, basically you've deprived me of my right to go to arbitration because you've retroactively applied this law after I had entered into the contract agreeing to arbitration, and so this is a breach of fair and equitable treatment, and that's what the tribunal found. It said that there had been, that the right to arbitrate was sort of a distinct investment that was worthy of protection, and that there was a right to have that arbitration right respected and honored. And ultimately, what's interesting is that the relief wasn't damages, but the relief was an order, because in the meantime, the state had commenced litigation. to retry the case. So the relief, the final relief, so not interim relief, but the final relief was to order the state, to order Jordan to terminate the local proceedings, so sort of an anti-suit injunction as final relief, and to restore the right to go to arbitration under the original contract rights. And if I have 30 seconds more, I just want to mention one other case because it echoes your Gazprom case, which is the Wintershall versus Russia case, which is ongoing now, where you have battling anti-arbitration injunctions from Russia. You've got anti-suit injunctions from the tribunal, which was truncated, then reconstituted. You've got enforcement of the anti-suit injunction at the seat in Dubai. And you've got continuing challenges. And part of the anti-arbitration injunction in Russia is also imposing the 7.5 billion euro liability directly on the claimant's counsel, and the arbitrators as well. So, ultimately, whether that ends up in a final finding on the merits of liability for breach because of the anti-arbitration injunction, we'll see. But it's very much a live issue.
Well, I'd like to quote unquote push back, but in the interest of time, because the CAD organizer are incorrectly calculating our time, I do want to open it up for any questions about the entire area of anti-suit injunctions or anti-arbitration injunctions. Usually it's kind of a controversial subject. Well, if we have no questions, the one thing I'll add is when I teach it, there's anti-suit injunctions and anti-arbitration injunctions are both forms of interim relief. And it's natural to think, well, why aren't ordinary interim relief standards applied? But they are not. U.S. courts will instead go to the applicable standard in the circuit that has been devised specifically for anti-suit injunctions and anti-arbitration injunctions. And those have a threshold requirement of the same parties and the same dispute. And then different circuits have adopted different standards for issuing anti-suit injunctions. Some circuits are conservative, like the DC Circuit and Laker Airways. Others are liberal, like the Fifth Circuit and CAIPA. And then there's in-between circuits, like the First Circuit in Quark. But it is not the typical interim relief standards that are applied. There was a question in the back, yeah.
Hello, good afternoon. I'm from a civil law jurisdiction. I'm from Portugal. And I was wondering if you consider the West Tankers case, where the European Court of Justice just ruled that anti-suit injunctions were against the Brussels Regulation 1. And just to add a comment that at least for our tradition in Portugal and that civil law tradition, that anti-suit and anti-arbitration injunctions are not some kind of normal thing. In fact, our law in Portugal prohibits anti-arbitration injunctions, not anti-suit, but anti-arbitration injunctions. And it's something that, at least as counsel or lawyers, never think about when we have a case. It's not something that we consider because it's so far away from our culture and our understanding of how the system works that we never use them. So just to add.
Does someone want to address? I certainly understand the anti-suit injunctions in the EU context are forbidden, and even in the situation when parallel proceedings have been commenced in bad faith and without the jurisdiction prescribed by the EU regulation. But that's not a system that I think you could apply on an international scale because it's founded and justified based on the trust that exists between member states. I guess the question I would ask to Portugal would be if you are truly pro-arbitration and have acceded to the New York Convention, why wouldn't you have your courts issued anti-suit injunctions preventing foreign litigation that is brought in violation of an arbitration agreement? Doesn't the New York Convention arbitration policy justify that kind of injunctive relief to further the policies of arbitration? I'm not allowed to ask you questions, but that's a question I would ask if you were up here on the panel.
Yes, I would say, if I may, that probably we would doubt that a Portuguese court ruling would be, effective in Europe, of course, it wouldn't be. So maybe in other countries like United States or whatever, India or other countries that you were referring to. So probably what we will do is, arrange something with our colleagues from that country and see what that other country might find more effective. But I've never been in such a case, so I don't know.
Any other questions? If not, I think we've kind of caught up a little on our time. I want to thank our panelists for tolerating my pushback and for sharing the wealth of information. Thank you.